Politica UK InfoPod. The battle over jury trials in Britain. Welcome to the Politica UK InfoPod. Today in the House of Commons, MPs debated one of the most significant proposed changes to the British justice system in modern times, a plan that could limit the use of jury trials in England and Wales, a legal tradition that stretches back centuries. The proposal forms part of a government effort to tackle what ministers describe as a crisis in the criminal courts, with a backlog of tens of thousands of cases waiting to be heard. But critics argue the reforms risk weakening one of the most important protections in British law. To understand the debate, we need to start with history. Trial by jury is often regarded as one of the cornerstones of Britain's legal system. The idea dates back to the Magna Carta of 1215, which established the principle that individuals should not be punished except by the lawful judgment of their peers. Over the centuries, juries became a symbol of protection against state power, a way for ordinary citizens to play a role in deciding guilt or innocence. Yet despite that historic importance, jury trials today are relatively rare. More than 90% of criminal cases in England and Wales are already decided in magistrates' courts without a jury. Only a small percentage reach the Crown Court, where juries are used for the most serious offences. And it is precisely in those courts where the system is now under severe pressure. The Crown Court backlog has grown dramatically in recent years, with tens of thousands of cases awaiting trial. Some victims and defendants are waiting years for justice. The government says the system is struggling to cope. Under the proposals debated today, some cases that would currently be heard by a jury could instead be decided by a judge sitting alone. The plan focuses particularly on offences carrying sentences of 3 years or less. These cases could be tried in newly streamlined courts, designed to deliver faster verdicts. Supporters of the reform argue this would significantly reduce delays and help clear the growing backlog. The government also wants to expand the powers of magistrates, so more cases can remain in lower courts, rather than moving to the Crown Court. Another controversial element involves appeal rights. Currently, defendants convicted in magistrates' courts often have an automatic right to appeal their case in the Crown Court. The new proposals could limit that automatic appeal in some circumstances, meaning defendants may need permission from a higher court to challenge their conviction. Ministers argue that repeated appeals and procedural delays are contributing to the system's growing backlog. But the proposals have triggered strong criticism from parts of the legal profession and from some MPs. Thousands of lawyers have warned that limiting jury trials could undermine an important constitutional safeguard. They argue that juries play a crucial role as a check on the power of the state, ensuring that decisions about guilt are not left solely in the hands of judges. Critics also say the backlog is not caused by jury trials themselves, but by years of underfunding, courtroom shortages, and staff shortages across the justice system. In their view, removing juries risks weakening public confidence in the legal process without addressing the real causes of delay. During today's Commons debate, several MPs raised concerns that concentrating more power in the hands of judges could fundamentally change the balance of the British justice system. Supporters of the bill responded that difficult decisions are needed to restore a system that many victims currently find painfully slow. The legislation has now passed its initial stage in Parliament, but the debate is far from over. It will face further scrutiny and potential amendments in the coming weeks before returning for additional votes. For now, the question remains whether Britain can speed up justice without weakening one of its oldest legal traditions. Trial by jury has survived for centuries. Whether it survives this reform intact is now one of the most important legal questions facing the country. This InfoPod was brought to you by Politica UK.